How you doing? It's good to see you. Good.
How you doing?
Good, thanks, dude.
Yeah.
Yeah, nothing like that. I do think we'll try to find some sort of take over. They had a lot of yeah, but yeah, I think that was no.
On to the next thing, right?
Yeah. August 8th.
It's because it's second generation.
That's it. Yes, that is true. The accessibility of ovens.
Yes.
That we're not putting you on site.
So,
Yeah.
and then the boys were Jasper is, I think, all.
I don't know how big, which one's wrong?
Jasper's the youngest. Jasper. I swear, I love him, John.
I like that. That's very fun. It's very like 8-year-old time.
Early core memories.
That's a good core memory to have though.
There's a lot of great outdoors down there, so it's gorgeous. I don't know what it was.
Oh, it's perfect. It was 70 and sunny. Malibu, Breeze, I think I recall that way. So at Miguel's, yeah, the climbers campers were, had the entire place was up. Because when we were out on the control, it was
And I'm like, they like go over into like a wow. It's like distracting and all these.
well, we did just play a great game, which was if you were a bear, which made you sleep.
That game.
Get you scurried off. Yeah.
I don't know if they would catch on the license. The dispensary one, I think they're gonna see how it goes before they start getting into it. They need a small sample size, I'm sure they'll watch it. Well, no, I was on the recreational about 2 years after they did this. I think it was like a fair.
Once they realize.
Yep, yes, sir. Like the gym shop, the bars in the back. No one's gonna see you. But maybe not 2 years, maybe it's a very, it was not 10 years. 10 years ago, she would have been in college and that was like crazy. I think that's where they lost their absolute mind. Because that was not in college, that was not a thing. So it would have been like 5, maybe 5 years. Well, the times are very different.
During the daytime.
It's just like a little, it's like a baby toilet. We didn't really do anything really do that by at night. They just say it was right, so it's there to here.
Hey, it's 5 o'clock. I want to call our meeting to order, and I would ask you to join me in the Pledge of Allegiance. Let's pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This is a special called meeting of the Scott County Fiscal Court, and it is the 6th of November, and I would ask Ms. Hamilton to call the roll.
Mr. Hostetler?
Here.
Mr. Jones?
Here.
Mr. Wallace?
Here.
Mr. Corman?
Present.
Mr. Ellison?
Here.
Mr. Pratt?
Here.
Mr. Livingston?
Here.
Mr. Culbertson?
Here.
Judge Covington?
And present. With that said, we will ask County Attorney Cam Culbertson to read the ordinance, and then at that time, after we read the ordinance, we will open the floor for any public comment. We would ask public comment to be held to around 4 minutes, and then we would have any questions or comments from magistrates as well, and then go from there. I will ask that I do want to make sure that the record reflects that there was an email and a request from a citizen, Janice Atley, that she wanted to submit information in regards to this consideration of the zone change. So I have shared that with the court to make sure that they had that information.
Okay, so this will be the second reading. Scott County Fiscal Court Ordinance Number 24-10, an ordinance related to changing the zone for 0.324 acres, more or less, owned by Melissa Stevens and John Stevens, said property situated at 1081 Stamping Ground Road in Scott County, Kentucky, from R1B Single Family Residential to B1 Neighborhood Commercial. Whereas the application of John Stevens, having been filed with the Georgetown-Scott County Planning Commission on June 28, 2024, requesting a zone classification change from R1B Single Family Residential to B1 Neighborhood Commercial for 0.324 acres, more or less, situated at 1081 Stamping Ground Road in Scott County, Kentucky. And whereas the matter having been heard publicly by the Planning Commission on August 8, 2024, pursuant to notice according to law and with a quorum of the Commission present and voting, and whereas after taking testimony on the application and fully considering same, the Planning Commission voted 4-2 to recommend denial of the rezoning request, and whereas the Scott County Fiscal Court has voted to overrule the Planning Commission's recommendation following a recorded vote of not less than a majority of the entire membership of the Fiscal Court after an evidentiary hearing, and furthermore made the following findings of fact: that there are other B1 properties in the area, that the proposed use is consistent with the future land use plan in the area, that the proposed use has minimal environmental impact, and that the proposed use is consistent with the comprehensive plan's encouragement of small businesses and economic diversification. And whereas, based upon the findings of fact and in accordance with KRS 100.213, the Fiscal Court finds that the map amendment is in agreement with the comprehensive plan. Now, therefore, be it resolved by the Scott County Fiscal Court, Section 1, that the Georgetown-Scott County zoning ordinance be amended to show a change in the zoning classification for 0.324 acres, more or less, situated at 1081 Stamping Ground Road in Scott County, Kentucky, as described in the application for the property of Melissa Stevens and John Stevens, wife and husband, from R1B Single Family Residential to B1 Neighborhood Commercial, all in accordance with the application for same, said property being more particularly described at Deed Book 441, page 458 in the Scott County Clerk's Office, Scott County, Kentucky. Section 2, that the Georgetown-Scott County Planning Commission is hereby directed to show the zoning classification change on the official zone map and to refer to the number of this ordinance. The first reading was approved October 24th, 2024. The second reading is today, November the 6th, 2024.
I will add that Melissa Stevens sent an email on Wednesday, November 6th. It was from Ms. Stevens, and it was an email correspondence from John Terry with KYTC District 7. And to clarify, based on conversation with Ms. Stevens, this is from Mr. Terry. This entrance is going to serve a small single shop building and does not require a traffic impact study, turn lane analysis, or any other analysis. This is an existing entrance that at one point served a single home, is now going to serve a small business and meets our requirements for a commercial entrance. If at any point the design of this entrance damages the roadway or any associated right-of-way, the owners of the property will be responsible financially for any repairs. Any questions about that? I'm happy to share that. Any questions or comments from any court member? Or would there be any questions or comments or public comment from any audience member? Mr. Mifflin, how are you, sir?
I'm doing well, Judge. I'm Charlie Mifflin. I'm chairman of the Georgetown-Scott County Planning Commission, and we are here tonight just for clarification, not to try to sway either party one way or the other, but that we heard this in August, and if you need to know why we voted to deny it, I can give that to you, but I'm just here to answer any questions that any party may have.
Chad Wallace.
I have one question, Charlie,
Yes, sir.
and maybe Elise might need to answer this if you all can. In our conversations, what the judge just read from Kentucky Transportation Department, was that information presented at the Planning and Zoning hearing, or was that done after the vote was taken and decision was made?
Yeah, it was not presented at that time, but we didn't, like the Highway Department, we didn't feel like that was a major problem anyway. They had already changed the grade getting up to their property, so yeah, we didn't see that as a major problem.
So what was the major problem? It was kind of half and half of a vote, right? 4-2?
Yeah, it was 4-2.
Yeah, it says of the staff recommendation under section 100-213, says therefore the proposed change is not consistent with the comprehensive plan future land use map for the area. And then I think one of the reasons it came before us for a proposal to change this, it says a development plan will be required before the start of commercial activity. Well, when it came to us, the existing residence had already been torn down and a commercial building had already been built. And so that's, I think, one of the reasons, or two of the reasons there that that was denied.
To your all recollection, which I don't think that any of you all have been here a really long time, right?
I've been here the longest, I've been here 3 years.
Okay, that's not a really long time. Not as long as not as long as Joe's been around.
I've been here for 77 years.
Yes, sir. I don't
know if you consider that long or not.
But not 77 years on the planning and zoning.
Yeah, no.
No, what I was going to say, my question was going to be is your second reason with regards to the residents already being torn down and all that stuff. I was going to ask, has that been a consistent decision throughout planning and zoning's decision-making process for the commission itself to always, if somebody has accidentally jumped the gun, to deny on that basis?
I don't know. I don't ever recall it coming before us.
Right.
Before, Rob, when you were on there, I can't recall, and Elise, I don't know that
I don't think
that has
it's
ever
been
come
a
before us
determining
before.
factor. Not when I was on there for 8 years, it wasn't.
But it's probably happened before. I mean,
I
you
can
know,
recall one case
yeah.
in Stamping Ground.
Yeah. Okay.
But you could run a BP1 out of a house, right? Like you could have a small shop out of a house, right?
Yeah, that's how my understanding.
Right, like, I mean, do you have to have, let's just say the house was still standing,
Right.
or,
Then there was no zone change request, right?
no.
That's correct.
Because they still want to run a business.
Well, they could then go to get a
Board
conditional
of
use permit.
Adjustments.
Board of Adjustment.
But a conditional use permit is not permissible if there is not a residence on the property. Is that correct?
That was kind of my question last time. It's like,
Yeah.
why couldn't they go ahead and do it? You know, because it was the same type of deal to me. If the house was still there, I guess I didn't, at that time, didn't understand the house was gone. Or that wasn't a part of the residence.
You know, realistically, that lot is so small, there's not much you you can do with it anyway. You know, and we were, I think the main thing was, that first thing I read is not consistent with the future land use map. But I don't know what else you would, you'd put in there, to be honest with you.
The future land use map is quasi-public, is what I
That's
believe it to
correct.
be.
Yeah,
Elise, is that correct?
that's correct.
Could you repeat the question?
Friend, the future land use map designation is quasi-public.
Yeah.
We can point to, the easiest one when we're looking at, or at least the most straightforward route when you're looking at a zone change, is looking at the future land use map. But there have been instances that I've been here in my, unfortunately, 3 years, to your point, to my 3 years, where an item may not exactly match with the future land use map, but with the actual chapters and sections, goals and objectives, where they actually align rather well with the actual textual document. That is the comprehensive plan, and which had received a favorable recommendation from the planning commission staff. And then potentially, in those instances, they may have received a favorable recommendation from the planning commission board. So, does that kind of answer that comment on that one?
Rick Hostetler.
So, one of your reasons, the commission's reasons, was going back to the fact that the house was already torn down and the building was built, and then y'all found out about it. So
That's correct. Yeah.
So I want to dig a little deeper into that. I think this was discussed at our last meeting, but let me go back to it. So you guys tore the house down, and nothing wrong, nothing against the law there, right? I mean,
Right.
I'm just because it seems as though guys didn't find anything out until after you've been through building inspection and electrical inspection and all the. Is that correct?
Yeah.
And then,
Mr. Stevens, would you come up to the stand? And
So we never built nothing like that before. So we actually went to the planning or the building inspections, got our permits for everything, and didn't realize our R1B to B1 was that different, or that was something that needed to be done first. We didn't know the correct order of that, but like to his point, you can run a B1 business out of your garage in a neighborhood because it's very minor impact, I guess. So that part we thought we were doing the legal thing as far as building the building because we got everything permitted, but I guess it's a little ahead.
yeah, that's what I was driving at. I mean,
I guess I was assuming that building inspections would deny a permit if it wasn't okay to do,
so what got
Well, there's
you?
nothing that says you can't put that building on your
Yeah,
property.
and the building can be there.
So
Like
they
it's
gave
just
you
the
the
zoning
permit
change.
for
It's the
it.
only thing we would need
Yeah.
to do as far as a business, like Ed said last time, was the developmental plan. That's when everything else would fall into play with what could be there. But to my understanding, I guess the zoning changes first and then a developmental plan's next.
More often than not, everyone goes through the zone change, you get the land ready for the use, and then you actually build the structure to execute said use. There's a distinct difference between what is use versus what is structure, or that this use would go in between. An item of clarification just on the commercial ability of a property. I'm certain there are homes that no longer retain a home use and can operate in a commercial manner. However, in our ordinance, under the R1B, you can get a conditional use for a home occupation in that zone. And a home occupation is defined as such in the ordinance. Professional office with one professional and no staff, studio, or personal services maintained or conducted within a dwelling or accessory building, meeting the following conditions. The home occupation must be incidental to the principal use of the residence and be limited to 25% of the ground floor area and in no event exceed 300 square feet. And the home occupation shall result in no exterior evidence except a wall sign not to exceed 5 square feet in area, which may identify the home occupation. So it is a potential that a home business may occur in that zone, but you need a home occupation conditional use permit first. And when we are looking at that, we're going to look at the definition and the standards that are set forth in that definition to determine if that is a home occupation or if that the intensity and the level of activity exceeds the home occupation status and therefore needs to be put a different zone, or the property itself needs to be rezoned.
Mr. Hostetler?
So one of the other things that was said in our last meeting was about
turning around instead of having to back out? I mean, is that property big enough that?
Yeah, we've got like an entire gravel. We got an entire, I think it's 60 by 40 graveled area directly in front of the shop. You can do a complete turnaround, pull back out. So there's no backing out. The previous home
Turn
that was
around
there.
with it. Can you turn around with a trailer up there?
Yeah, you can. Yeah, it's I actually put it far enough back that you can actually back a trailer into the building. So, and that's what the intentional use was going to be for that. The prior home that was there for I don't know however many years, they actually did have to back out into San Diego because their garage was right there in the middle of where the driveway is. So they would pull in and back out into the roadway. So it was actually quite a bit more dangerous now. But where we took everything down, you can actually see pulling directly out of that property both ways pretty well.
Yeah, I know your neighbor down there now, he actually pulls up and backs into his driveway.
Yeah,
so
he's
he can
right up
pull-
against the wall, so he's kind of in a hole. And his
straight
spot
out,
is
yeah.
very bad. Like if he was to move his driveway to the other side, he could see a mile each way too.
Yeah,
It's just-
he's got a bad spot.
It's just
Bad
that
spot.
wall is right up against the road, and we actually, the wall that doesn't belong to us, that's on, I guess, state highway property. And we actually reached out to them and told them we were fine if they wanted to remove that wall and slope the whole thing back so it could clear visibility for everybody passing. And we were totally fine with that, but we couldn't remove it ourselves. So.
Mr. Stevens, when you said that you were directed by building inspection, and you thought that after you applied for, I'm sure that you had to file for a deconstruction permit, and then you also had to apply for a permit.
Yes.
Someone from building inspection advise you and say, this is the route that you need to go, or did you just assume that because of the applications and the approvals that you were doing the right thing?
Well, I assume that went kind of hand in hand that to build a shop, because I mean, you give them the prints to what you're wanting to build, how it's laid out, and I guess not thinking about the zoning because you don't have to have a zoning change to build a building. So
no one said.
So no one advised to. Yes.
Okay.
So this is just a general question. On that application, when you filled out to build your building, there was nothing like what's the use of the building or any question like that? Or what?
Yeah, and I put down the exact same thing that we're talking about right now, just for like a storage location, shop, construction area. So that was actually on the permit too. So.
I think they're trying to pull it up right there.
Let's see.
Well, I was meaning like the actual finish, because
Oh, yeah.
we've spent thousands on groundwork to make it a huge pad.
I haven't seen it. I've never looked in there, just picture.
And when you asked the state to remove the wall, they wouldn't let you remove it?
No, I think not. Well, there's also a telephone pole that's there too, where they have to be relocated for the utility
Mr.
wires.
Jones might want to see it.
So that was another issue with that, and there's also the water meter. It's
Yeah.
right there close to the wall, so all the utilities would have to be relocated. But removing that wall would make it much easier for everybody to see around that cover, especially with Betsy Way being where it's at. You could see all the way around that thing. So.
And Charlie, the Planning and Zoning Commission at no point considered that as a condition of approval, that if the zone change was approved, that the utilities would be moved and the wall would be torn down. Was that ever discussed?
No, we never discussed that. I don't think, did we?
No.
Yeah.
Okay.
No.
Yeah, this is all done before we ever went to
Right.
planning and zoning. We actually reached out to the road department to see. But yeah.
Yeah, we just, we noted that they would need to contact Department of Transportation, which they have done. And that's all we had
And to
said.
my understanding, that was the only thing that was really.
Right.
During the planning commission stuff, that it was, the biggest issue was the traffic in the area, so that's
Yeah.
why we went to that, to get that straightened out.
Understand.
Yeah.
Cleared up.
Thank you.
So,
Mr. Hostetler.
sorry. One more question, if you don't care. Well, I'm just wondering obviously, if the court decides to approve this tonight, obviously you could sell it tomorrow, and we all know that.
Yeah.
And somebody else could do something else with that property. But your plans what kind of activity are you talking about? Because
Just-
to me, it seems like one of the biggest concerns, and it is a concern, is ingress and egress safely from that property. And like Rob was saying, there's other property owners, I'd back into my driveways over there too.
Yeah, you can see his little red
So
truck
our,
at the top
our
of the
property's
picture.
on the outbound of the curve. His
Right.
property is kind of on the inbound of the curve.
Right,
So we can
and
see
listen,
pretty well.
there's other cases in our county that have similar issues. I mean, there's no perfect place, I don't think. But my question is, what kind of activity are you guys planning on?
Mainly storing equipment, tooling, trailers, all that stuff inside the shop, locked up.
Is that going to be something you're going to be in and out of there multiple times a day?
It would depend, yeah. It would be no more than a single family home would be driving in and out, leaving their home and
Going to work or
yeah,
whatever?
it would be the same.
Just-
Actually, probably less than that. So
When you're talking about trailers, are you talking about trailers that are hauling backhoes?
no, just like a little
Any
small,
kind of
like
small
a little small
equipment?
box and trailer to hold, skill saws, hand tools, that kind of thing. Small ladders and stuff, like a 10, 12 foot enclosed trailer. Yeah, nothing, not like a big gooseneck or nothing like that. Just a small trailer. and to the future, like if somebody else were to buy it, if we sold later on down the road, they would still have to go through, I think, what he's called like a developmental plan to, and that would have to be approved for whatever they were trying to put in there as a B1. So even for future use, it would still have to be approved.
Just as a question, what would flip that trigger? If, say they sold the property and somebody else comes in there because he thought he was going down the right path after going to, building inspection. So if he sold it and somebody else comes in there and going to do whatever, what flips that trigger that they would come to you guys?
One thing to consider is.
Holden, would you come up? Thank you, Holden.
One thing to consider is with the commercial building permit applications, there is a section on that box that asks if a development plan has been filed. So that simple yes or no should indicate whether or not they should be consulting with the planning department on these matters. Now, of course, again, anytime you have a change of use, we would like to take a look at that to, again, confirm whether or not it meets not just that zone, but if he does file a development plan, is that in line with that development plan or is that not in line with that development plan? And so as far as what triggering mechanism creates that movement, it would have to be an applicant presenting new information, something that was not previously either considered or approved.
I think what maybe just what Rick's asking, because I'm kind of curious myself. Somebody comes, it's a cash offer, they sign an attorney prepares a deed, they transfer it over. Now the new owner starts doing something that's a lot more traffic. I mean, I don't think there is a triggering mechanism. If that person doesn't follow the rules and go down there and apply, it's and they may not know. They may think I'm already buying the business and I'm just going to,
Yeah.
I guess is that kind of what you,
Yeah,
there's nothing there in place, and it would be hard, I guess. It'd have to be something in the deed or something, I suppose, or.
But what you're saying is if a transaction did happen and somebody bought it and they took one of the garage doors off and put in a regular door and they started a market, there's no
Right.
trigger.
Right.
There's no trigger that makes them come to you for a change of use. Is that what you're saying, Kelly?
No, that's right. I mean, we had a similar situation, I guess, out in the county where somebody opened a shop and decided to, start asking for, permission afterwards. But, yeah, that's it. And I know it's a tough question because I don't think there is an answer. And I'd be curious if there is, but.
Again, we want everybody to follow the process and follow the rules. Ultimately, what we end up with, right, again, is we try to create a system that works best when people do follow those rules. So we end up in a situation a lot like this, that if we become aware of the fact afterwards, we do our best again to again then review the project for compliance and figure out if there's ways to mitigate that. Now, there are mechanisms in place that would alert our department, whether that is a complaint that's made. If a code enforcement complaint is made, we would typically be looped in on that. Again, we just discussed that on a commercial building permit, there is a section that says development plan, yes or no. That should be a flag that we are involved in some capacity for that. Again, if the question is what happens if somebody comes in and never gets a permit and nobody ever says anything, you end up, if a tree falls in the woods,
Right.
we don't want that to happen. For us to do our jobs effectively, we need to be aware of development as it takes place, and again, preferably before it takes place. I do want to harken back, though, to something I believe that Commissioner Jones, or I'm sorry, Magistrate Jones pointed out there. Tearing down the house, building the shop, that is okay. That's not what we're here to consider. That's not what the Planning Commission considered. The primary purpose of this process thus far is to take a look at the specific use and to see if the use that the applicant wants could fit into the R1B zone. It does not. That's why we are coming forward with this zone change. That's why we've gone through this process. And so it's very important to draw that distinction between the structures and the uses, and recognize that no matter what happens here tonight, he can keep the building itself. It just can't, potentially wouldn't be allowed to be the same type of use as what he currently has in mind. That's all I've got to say.
If customers were not coming to that building, would that be a difference?
I think that would be a distinction. I'm not sure if that would make a difference. I would also just like to be very careful, having already been through the Planning Commission process and having the Planning Commission having reviewed it for a specific set of circumstances. I don't want to speculate as we stand here. Now, what I can do, though, again, is right now underneath our code, we have no statutory limits on how often somebody can come back in and apply. So depending on the outcome of tonight, if the applicant feels like, again, regardless of the outcome tonight, if the applicant feels in the future that there's actually a different use that would better suit his needs, you can always apply to our department, and we can again go through the entire review process to make sure that, again, it aligns with the community.
And just so I'm clear, if I remember correctly, staff at the Planning and Zoning recommended to pass this to the Planning Commission. Planning Commission, on a 4-2 vote, decided not to, based on comprehensive plan and where it fit with the model around the area.
That's correct.
Okay.
Any other questions or comments?
Do you find that, this might be for Charlie, I don't know who this is for, that it doesn't fit with the area considering, and I haven't counted all of them, so now I assume that this email we got from Mrs. Atlee's correct. And I looked earlier that there's 1, 2, 3, at least 4 B1s already in this area. Like I'm trying to figure out if it doesn't fit with the future land use map, why there's already so many B1s on both sides of it, before it and after it.
Yeah.
So how did the Planning Commission get to it doesn't fit with the land use map when there's B1s that surrounded on both sides of the road already?
Yeah. So again, I would refer back to number 1, the record as it stands coming out of the Planning Commission. But further than that, what Ms. Ketz had spoke to, she's just okay. What Ms. Ketz had spoke to, the future land use map provides that it's going to be quasi-public. Obviously, the zone that we're looking to change it to, there's no quasi-public zone, and so on its face. And the most direct read, no, it does not directly align with that. However, as she pointed out again, if you compare that future land use map definition to this proposed zone, there's significant overlap. Enough overlap, so much so that while staff recommended approval, it was not necessarily clear enough that the Planning Commission took action on that recommendation.
And as you can see, Ms. Katz has had the future land use map.
This is not the future land use map. This is the adopted zoning ordinance map. In a minute, I can pull up the future land use map.
Okay.
And if I could just clarify one other thing with both B1s coming before and potentially after, is any sort of zoning change is not designed to create precedents, but rather, again, it just so happens that a lot of times areas in the same area are going to have similar conditions, and so it can help lead to similar decisions down the road. But there's no sort of precedence creation that because we approve this one case, we must now approve this next case.
Each stands on its own.
Each stands on its own merits.
And Ryan, I would say some of those that are B1 were probably given that designation when we approved, when we developed our Planning and Zoning Commission back in the 70s. You know, the vet's office and the little store down at the creek were probably given that designation at that time.
But that new vet's office.
The new
hasn't been
vet's
there.
office was approved. That
weren't
came
alive.
when I was on.
I mean, the old, I remember, but the new, I mean, I used to hunt on that farm, so.
Yeah, that was approved.
I know that thing went
remember
there in
that. I
BB
remember that
B1.
application being
Combs,
approved.
how long has Combs been?
Combs
Now, Combs is R1B
But he's
because
grandfathered in.
he's
as a-
grandfathered in.
But it looks like there's that old grocery store that sits
Right
at the
on the
corner
creek.
of Lyle and.
Did Ms.
Or, I'm
Hafley
sorry,
own
Lloyd.
that?
Yeah, Miss Hafley owned that a long time
I
ago.
might have had a pork chop sandwich there.
Yeah,
Yeah.
a couple sandwiches in there.
For clarification, this is on the TV right now. This is the future land use map as adopted by the 2024 comprehensive plan. The area in blue is quasi-public uses. Area in red, which is where the vet area is commercial. The other side of the road, in between the creek, floodplain, and the road itself, that is a low-density residential, and then north of the creek, as you approach and go up towards camping ground, that is future land use agricultural.
So what, quasi?
Quasi-public.
It's a what?
It is a zone that's intended for government uses and government offices, so schools, government agency buildings, parks, those types of uses, that's what their designation gets to be.
Which is a lot busier than what we're talking about.
Yeah.
A lot of
Yes.
times.
There is no associated one-to-one zone. Pretty much every single zone has a one-to-one. This goes with this, that goes with that. Quasi-public is unique in that schools are in ag zones, schools are in residential zones. They're in business zones. I don't think they're in any industrial, but that doesn't mean that they couldn't be in industrial. Schools and parks and government offices are not held to a zone because they are government and state agencies that can go essentially, they're exempt from zoning consideration and regulation. So they can be in any zone. And so there is no zone that is the school zoning ordinance designation because of its condition of being a government state agency. So there are multiple on that side of the road that are privately held off parcels, such as this one, such as the Great Crossing Baptist Church, where they have a QP or quasi-public designation. They're privately held, but like they're close to the school, and the location and the general analysis and understanding was like this should be covered school community focused areas because the school is right there. So that's why this area kind of got that designation, and then the vet had been there for however long it's been there, and this had a long-standing commercial use, so the location was designated for commercial use.
So does a B1 fit in quasi?
Again,
That's
as-
the question I
Yeah.
still can't
Anything
understand.
could be quasi-public. The B1 could be quasi-public, future land use, the R1.
So anything can go in it.
And so, again, the purpose of the future land use is to help, provide direction when a zone change application or something like that comes through.
It's not necessarily to restrict it.
Not necessarily.
I'm with you, but we generally, but if we're going to hang our hat on one of these things, we have to say, hey, that this fits in this land use map.
Yeah.
Right?
And-
That's one of the things that we've even said in here. So my question, I'm trying to, for myself, at least answer, does a B1 fit in the land use map?
I don't know, does an ag business fit in the green belt?
That's not the question we're answering tonight, David.
I'm just saying.
What I would refer back to again is
consistency is good.
Yeah, and I would agree with that statement. As Magistrate Ellison pointed out, the intended uses that Ms. Ketz has just pointed out for the quasi-public zone can oftentimes be more intensive than the same uses that are found in the BP1 zone. So that allowed staff to feel confident with our recommendation. However, as discussed at the Planning Commission, there are other issues at play here that the Planning Commission as a legislative body did not feel that it was appropriate for this area. And so I'm not going to stand here and second guess my Planning Commission. What I can do though is again reflect back on the record as it's already been presented and allow you guys to answer that question on your own.
And if I understood correctly earlier, the planning commission, they stated that it did not meet the comprehensive plan.
That is correct.
And did they state any other, was there any other statement made in support of their decision?
If I could, and again, this is, and Charlie, I'll let you reflect back in case I get off on our conversation. When it comes to something like neighborhood commercial, there became a question of which neighborhood was this commercial enterprise serving, and was it serving that neighborhood or not? And I think that was a question that the Planning Commission had. And I don't, again, based again on the record that the Planning Commission voted to deny this 4-2, that they did not find that was sufficient.
So
was there any explanation from the commissioners that dissented from the majority why they were voting in favor of as opposed to against?
I'm now reading from the record.
In the minutes record, it may not include it, but that does not mean that the verbal testimony and conversation included their justification as to why they voted to go against the denial request. So, fair process of math saying that they were okay with it. We do not, it's not a word for word verbatim minutes, so unfortunately we don't have that in the minutes, I believe, themselves.
Yeah, and again, the minutes as I see them in front of me currently did not specify the reason behind those two dissenting opinions.
other questions or comments?
So I drive by this every day, twice a day.
Thank you.
Thank you.
It is a dangerous curve, trust me. If you're speeding and he's pulling out that driveway, so there's no doubt. There's no doubt in my mind. That's one of the reasons I'm against this. They've done a great job cleaning that property up. They've got a nice looking building, but I just don't think it's appropriate for that area.
Wouldn't it be the same if it was residential, though? If the house was still
be.
there?
It could be.
And I go back to, we just did the Country Boy at Hy-Vee Meats, which is a probably worse curve in
No.
some ways.
No.
I don't know if it's worse, but it's a tough curve.
It's a tough curve, but it's not
with a lot more people maybe coming.
Because you're coming into
And
the
you're-
curve down the hill, so.
So.
Actually drove it yesterday, Monday and Tuesday, and I mean, I agree with you, but it's also that second entrance into the Great Crossings Baptist Church is 10 feet from it. It's been there 50
Yeah,
plus
but
years,
most people won't use that at the church. They'll come up to the top when they don't use that. They'll pull into that entrance, but they won't come out at that entrance when they go to church there. And, when it was a residence, you didn't have to worry about a trailer coming out of that driveway. Now you're going to have to worry about a trailer coming out of that driveway when you're coming around that curve. So just think about that for a minute also. And then, once you put this as B1, like I said, he could sell that tomorrow. You don't know what's coming in there next.
I've watched many things go through Planning Commission and come through here that I've had that same argument. And I've been told over and over again, that is not an argument in which to deny a zone request. That's a personal opinion, and I'm just saying, want to be on the record with that, because I have fought and complained about sometimes how this process works. Looking into the future and what could be. Unburdened by what has been.
To his point of being dangerous, so we did shave the bank off on both sides. We even got the church's permission. They let us shave some of that off as well, so you can actually see to pull out of our property way better than it was. But to your point of someone coming around the curve speeding, that's any driveway anywhere. So if they're speeding, they're the ones breaking the law. So I mean, you're not going to.
Yeah, but you don't really have to be.
I get your point.
You don't really have to be speeding, because the speed limit is 35 on that right there in that curve. So,
yeah,
like I say, when it was a residence, you just had to worry about a car pulling out there. But Now you're gonna have to worry about a trailer coming out there at the same time.
And to that same point too, if it were still a residence, you could still pull a trailer out at the same time.
Yeah, that
So that's
driveway
nothing-
they
that's
had
nothing
there, they
different.
wasn't gonna put no trailer in it, that's for sure.
Yeah, that's nothing different than it is currently though, so just bring that point, we did shave the bank off.
Yeah, like I said, y'all done a nice
You
job
can see
cleaning the
really
property
well
up.
pulling out of it. When we first bought the place, we actually used the church because you couldn't see to get out of it. Like it was just, everything was growed up, but we cleaned everything out, so.
So, appreciate it. Any other question or comment?
Yes.
Would you share your name, sir?
I will. My name is Patrick Parker, and I am the caretaker of the Great Crossing Baptist Church, the Johnson Family Cemetery. I've been taking care of that cemetery for 4 years now, and so my concern has to do with site protection of the historic land that surrounds this property in question. So it doesn't particularly and specifically address this parcel of land, but what it does is it addresses the 6 acres that belong to Great Crossing Baptist Church, which is beside this property as well as the acreage behind this property here. Now on the 30th of November, coming up here in about 3 weeks, we have got a gentleman traveling here from Simpson County that is going to do a ground penetrating radar scan, a site scan of the entire area that extends all the way around this property. What it is that historically there are graves that decades ago the farmer removed all of those headstones, all of those gravestones. We know for a fact that there are unmarked graves all around that Johnson family cemetery there. So I'm in communication with the Kentucky Heritage Council, and this is possibly through application going to become a Kentucky Pioneer Cemetery that will include all this land around this parcel in question. And so I do not have opposition to the issue at hand today, but our concern is we do have tourism and we do have historically minded folks that come to visit, because this is most likely the oldest cemetery in the county, established 1785, the church itself. So this is the oldest part of the county right here. Colonel Robert Johnson established Johnson Station, as you know, 1783. So our history is bound right here. It's an important part of our history here in Scott County. So I just wanted to point out the historical aspect of what's going on right here and what will be happening here in 3 weeks from now. Thank you.
Oh, I have a question. Now, would it be, it's not going to, the radar scan that you're doing, will that actually happen on their property currently?
No, it will not. It will not.
And don't look forward to in the future, not.
You know, I'm not well versed in how all of the historical preservation goes with the state government and the Kentucky Heritage Council. I don't know about this, but at this point in time, here in the very initial stages, we're going to stay right on the church's property and just see what kind of results we get from this scan.
Sure. Okay.
Mr. Parker, I'm going to ask you a preloaded question here. Let's say that there's no, on where the parking lot is, and there's no bodies that's identified in that area, would the church ever be open to allowing access to that property if the applicants put a driveway that abutted up to your all's property so they could access your parking lot and your driveway? I know you can't speak in
I
church.
can't speak for the church. I don't know. I can't say.
I'm just thinking as far as in terms of site distance, if they could access that area to the top of the, closer toward 460, it's easy.
Rumor has it that there are grave sites underneath the pavement in the church parking lot. So, but we're not going to go there either.
Thank you.
Thank you.
Any other questions or comment?
I'll make a motion, we approve the second reading.
Second.
We have a motion and we have a second. Ms. Hamilton, will you do a roll call vote, please?
Mr. Hostetler?
I mean, yes.
Mr.
Mr. Jones?
No.
Mr. Wallace?
No.
Mr. Corman?
Yes.
Mr. Ellison?
Yes.
Mr. Pratt?
Yes.
Mr. Livingston?
Yes.
Judge Covington?
Yes.
Motion carries.
Motion carries. With that said, that is the end of our business. Is there a
Appreciate
motion
everybody
to,
working. I know it's complicated, but I
is there a
appreciate it.
motion to adjourn?
Judge, can
Yes.
I say one thing before you adjourn? Withdraw my motion.
I've always said a motion to adjourn never failed, but tonight's the first time.
Yes, sir.
It shows tonight some of the problems that planning and zoning faces from time to time. It's brought up a couple of times that they could sell their property, and if it was a kayak canoe rental business for the creek right there, if it was arts and pottery shop, or if it was an automobile paint shop, you know, two of the three could go fine, it would be just fine, nobody'd have a problem with it, but yet they don't have to come any place, and we wouldn't find out about it until, you know, some of the neighbors complain about it. And so that's some of the things we face that we don't want to have to come back before you. But the problem that we did have with the building inspector, a lot of communities, that building inspector's office and code enforcement is also under the planning and zoning umbrella. And so Mr. Culberson and Judge Covington, think about that. We would love to have them under that umbrella so that we don't have problems like this.
I fought that battle
come
years
up
ago.
from time to time.
It's
I thought about that
a
too.
good idea.
I've asked this question.
Great idea.
And I'll ask it again.
No,
Is
we
it-
are-
Car before the horse.
We had a second.
I withdrew my first, so we're still.
Charlie, I have this question.
Workshop then.
I did have a question, or at least an idea. We keep hearing about this, you know, unintended consequences of the thing in the green belt that you talked about earlier, and this if they sold it. Could we look at, or is there any way that the Kentucky statute allows for conditional use approval with sale? So we're going to approve this, but if you ever sell your property, it has to come back for approval.
Well, then you're affecting value.
Yeah, but they know going in. It's not like.
Yeah. That's not our job.
Yeah, a conditional use is very different from a permitted use. So with this action that's been made tonight, whatever was allowed to be permitted uses, such as residential uses, are no longer applicable anymore.
Yeah.
Conditional uses, like for.
So,
in the-
Elise,
Sorry.
It's okay.
just
It's all
sticking
right.
to the agenda.
Yes.
I think we
This
can
is a
adjourn.
special call.
Yeah, we can.
Yes.
We can adjourn, and then you could.
You can come back Friday
You
morning.
can come back on.
That works even better.
So a motion to adjourn was made, and a second.
Kelly got the second.
Kelly with a second. All those in favor, please say aye. We are adjourned.